Last night, Dr. Kerrigan shared with me that Dame Linda provided him with quite a menu for thought. We now look forward to his serving up his favorite dishes for our enjoyment.
Thank you very much for that awesome introduction. All protocols observed. First of all, I'd just like to say hello and good afternoon, and thanks for having me. As I've mentioned to a couple of my fellow panelists, I come from a family of lawyers. Both my parents were lawyers. My grandfather was a judge of the Middle Temple, my uncle an SC here in Trinidad, and my girlfriend is a lawyer. So I think they'd all be pleased and excited to know I've been invited and welcomed so warmly by the legal fraternity in TNT. So again, thank you to all the organisers, and of course, the Honourable Dame Linda Dobbs for an excellent lecture. Now, anthropologists, as part of their training, develop a commitment to examining how inequalities in society are perpetuated, both culturally and institutionally. So when I was first invited to contribute to this discussion, my guess was I was being invited to offer the social and economic justice case about the law. That is that, built into the architecture of modern-day societies and their socio-cultural and economic structures, is a cumulative bias for certain groups and worldviews over others. This cumulative bias resides in supposedly objective categories, processes, and laws that cloak the workings of power. For example, bias can be seen in places such as a racially slanted criminal justice system, the sexual division of labour, wage inequality, and in the guise of supposedly neutral policies and decision-making. Yet once I read and then had the pleasure of hearing Dame Dobbs talk, I realised quite clearly I was invited here to offer a slightly different take. And that is a take on culture, cultural relativity, and what I will call the cultural obstacles to achieving the implementation of our human rights obligations. But as Dame Dobbs did in her talk yesterday, let's start with a little context. In 1947, in a statement against the proposed Universal Declaration of Human Rights, the Executive Board of the American Anthropological Association, of which I'm a member today, submitted a prepared statement to the UN Commission on Human Rights. In it, many leading anthropologists of the time described the Universal Declaration of Human Rights as a type of imperialism, a type of cultural imperialism, if you will. The anthropologist asked, how can the proposed declaration be applicable to all human beings and not be a statement of rights conceived only in terms of the values prevalent in the countries of Western Europe and America? Now, the anthropologist's point here wasn't to say we don't need to protect the disadvantaged and fight to ensure freedom for all. Rather, it was a defence of the small and remote communities, traditionally the focus of anthropological research at the time, and quite apart from the large urban centres and metropolitan countries of Europe and North America. It was also a defence of the position that cultural difference is itself a universal value and human right that should be protected from ethnocentrism rather than lost, as more powerful cultures driven by capital accumulation and territorial expansion led to the homogenization of all the world's cultural differences into a sort of nebulous blob of everyday life and debt slavery. Now, it's important here to not misrepresent what these anthropologists were standing for. In defense and protection of cultural difference, which is really a driving ethos of anthropological work, anthropologists were not claiming in 1947, nor are they claiming now in 2015, that the tolerance of cultural difference means a loss of morality and an inability to make moral judgments. In anthropology, there is always a limit to cultural relativity, no matter if we all do not always agree on where that limit is. Now, the point to consider is this, is that the culture people live, i.e. the values and norms they live their lives by, are learnt and adopted through a process of enculturation, i.e. learning as a child, and then later socialisation. Enculturation and socialisation shape our values and the meanings we put to the world. They teach us what is normal, what is socially acceptable. It's an invisible power over all of us that includes things like culture, ideologies, religions, values and customs. And the takeaway here is not to think these culturally relative processes are a justification for anything goes and a moral vacuity. But rather, when we want to understand human behaviour, we need to be cognizant that people as individual members of multiple socio-economic and cultural groups become committed to who they are through socialization into the values of these groups. And as such, we shouldn't judge people by other standards like our own, but by those standards of the groups under study. Now, these anthropological concerns are still a large part of the human rights debate, and some critics still suggest the human rights approach being pushed around the world is a replay of imperial efforts to force change of culturally distinct societies. And this criticism has a variety of levels, from the overt, like why should we do what the powerful tell us when the powerful themselves do not live up to such standards? And I think the racial caste system in the USA and its ongoing examples of a racist criminal justice system, or the British Home Secretary's statements in recent days about taking no responsibility for refugees caught up in the Mediterranean boat crisis, are good demonstrations that the powerful societies running the world don't always themselves live up to or implement their human rights obligations, no matter how they describe their actions to us. The concerns of cultural imperialism are also important to consider on a less overt level. For example, one takeaway that immediately leapt out to the anthropologist from Dame Dobbs' rich talk is that it focused on the implementation of fundamental human rights and stepped over the question of has Trinidad and Tobago as a society agreed on what fundamental human rights are. Dame Dobbs' position, of course, makes sense for lawyers from legal systems and cultures that have developed over a long period of time, like in the context of European states, where what are considered fundamental human rights there are fairly well established. And the focus is more on the implementation of those rights than a consideration of whether certain individual rights should actually exist or why they should be considered fundamental. Although, of course, again, the new Conservative government in the UK says it intends to repeal the UK's current Human Rights Act, so it's never that straightforward in any society. So one observation I had about the questions being put to the panel is that there was an assumption in the lecture yesterday that our society has agreed on fundamental human rights and that we should move straight to the implementation phase. While I wish that was the case, and I do think for many members of our society, such as members here and myself, that it is the case. But I think the example of secular orientation and the law demonstrates that it's not truly the case. Now, my feelings as a private person is state homophobia, and I have written about this elsewhere, is a way the Trinidad and Tobago state uses the law to police and punish deviations from the dominant ideas of morality and religion that exist in our society. Now, Dame Dobbs encourages us, and specifically many of you here in the front of me, to deal with such outdated laws, and I support her call. However, I would like to map out some cultural obstacles to this. The first is religion. While Trinidad and Tobago might describe itself as a secular state, I think in practice this is a lot harder to support. For example, just two quick examples I can think of. God and religion are regularly called down on hustings and political platforms. And if I'm correct, the first clause in our constitution states that the nation is founded upon the principles that acknowledge the supremacy of God. Which leads us to the question, is it possible to have fundamental human rights if you do not have total acceptance of a secular state? For example, various religious beliefs impinge on the acceptance of fundamental human rights here. Some call for the punishment that equates as an eye for an eye, while others find gay or homosexual relationships against their fundamental belief in marriage or the relationship between men and women. Now this brings us to the terrain of cultural relativity again. Should we protect state homophobia and the larger impact it has on wider social cultural homophobia in TNT, because on one level, homophobia is historical and cultural here? I would say no, we shouldn't, and it would be a misunderstanding of the anthropological project to claim so. As I claimed at the outset, anthropology has a deep commitment to examining how inequalities in society are perpetuated both culturally and institutionally. As such, something like Section 8 of the TNT Immigration Act will be something to fight against and raise awareness of. However, culture doesn't change overnight, and anthropology as a bottom-up social science recognises you have to carry a public composed of multiple beliefs, cultures and ideas with you, i.e. you have to shift their cultural frames rather than simply think laws or top-down pedagogy will carry them for you. Although of course there is a relationship between the law and cultural change, but we need to be clear on how this works. Unpopular laws make unpopular governments, so we need to find ways to make governments lead by example rather than run away scared. Other cultural dilemmas emerge when you further consider the topic. In her talk, Dame Dobbs recruited the moral question of equality of marriage, and there's a growing acceptance of civil partnerships or marriages between consenting males around the world. But I might suggest from first-hand experience and research in the field here in TNT that that comparative argument doesn't often work very well here. The majority of men who have sex with men in TNT are not members of a large community who self-identify as homosexual. So homosexuality is not really a pole of political organisation and mobilisation as it is in Europe and North America. Here, the idea of homosexuality and gay marriage is actually something you hear members of the public being firmly against, while at the same time, in private, they tell you that if gay men keep it private, then that is okay with them, which is sort of the legal status quo, that we have a law, but we don't repeal it, which of course, as Dame Dobbs noted, is a cop-out excuse with all the dangers of violence, harassment, and discrimination it includes. So I would venture the general cultural obstacle to equality before law for gay men isn't so much the general public believe men who have sex with other men should be arrested, although of course the situation is extremely messy and complex, but rather that homosexuality is frowned on by God, and God is held higher in the local society than the UN's Universal Declaration of Human Rights. Another way to look at this issue is to say homosexuality is mostly invisible, and when it's public is ridiculed and attacked. For example, in culturally relative terms, we have no openly gay ministers in our government. There may be ministers who are in the closet, but none who feel safe, brave enough, or morally obligated to come out of the closet. In the UK, Chris Smith became the first openly gay Secretary of State in 1984, more than 30 years ago. And today the UK finds itself with the queerest legislature in the world. 32 of the United Kingdom's 650 MPs call themselves gay, lesbian, or bisexual. And at 4.9% of the population of MPs, this is pretty close to what academics claim is the sexuality of the population as a whole. So while I support Dame Dobbs' call for judicial activism against state homophobia, I think there are many cultural obstacles to this change that will take at least a generation to filter through. What is the judge's dilemma in that scenario, and how far should they take their activism? And what are rogue judges who don't see the case in these positive lights? Now, this contextualization of our internal obligations in the face of local cultural obstacles and pressures isn't meant as a cop-out from change. This isn't a recruitment of cultural relativism to excuse any of us from doing what we as learned professionals know is morally correct. However, it is to recruit anthropological reality and suggest implementation is not so simple. Again, this is not to say culture doesn't change, and if I had more time to speak, I would have described how culture is not static and unchanging, but rather culture is always in process, is always in the process of change, and groups and their values do shift under wider environmental changes. So for instance, more public visibility of important people in the society coming out of the closet is going to be an important element of shifting the cultural frame of the society, just as judicial activism against state homophobia is also an important element. And of course there are other elements too, like the power of religion, tradition, and historical legacies. But again, none of these obstacles are insurmountable, but rather cultural change is behavioural change. And that doesn't happen overnight, it's a long-term process. And changing the law is obviously part of that long-term process. Now, the other matters for the panel's consideration, capital punishment, corporal punishment, and the imprisonment of young people, I would also describe similarly as forms of state violence, but not in identical cultural ways to the issue of sexual orientation. The ethical reasons for their legislative reform, I think, were covered well in yesterday's talk and today by my fellow panelists. Yet let me conclude my contribution by offering 3 short cultural questions about each piece of legislation that might help us to understand how each has a distinct cultural messiness to resolve. In the context of corporal punishment, a ritual many people who are still alive endured and some still practice and support, how is corporal punishment any different to bullying? And why would any members of a society support a form of abuse that clearly does not make society safer and persons more respectful of others? Education is clearly the necessary tool in the long term to prevent the strong abusing the weak. But culturally, why is this not something currently agreed upon as a fundamental fact of life in TNT? Is it a failure to agree on fundamental rights of wider society? Number two, in the context of capital punishment, again, let me sidestep the ethical arguments against it, and know that I am against it, and ask, why would this issue be considered a culturally relevant one? How do history and tradition, as Dame Dobbs put it yesterday, stop its repeal? Is capital punishment really about punishment and deterrence, as some claim, or is it like sexual orientation, an issue tied to God and religion? And if so, how do you get buy-in from politicians who answer to God before they answer to the universal declaration of human rights? And number three, the imprisonment of young people. Now perhaps I missed the connection here, but I thought this legislation had the least to do with cultural relativism and the most to do with social and economic rights. And as a consequence, institutional prejudice against the poor and predominantly black men, a form of state anti-black racism, if you will. A class, a warfare type of argument even, that politicians must be seen to punish and not save the criminals. That we don't build the right facilities or choose to educate or retrain our young offenders, instead punish them, perhaps has connections to some religious doctrine too. Which leads me to my final question that's emerged from these discussions and Dame Dobbs' excellent paper on the implementation of our human rights obligations. And this is that perhaps the judge's dilemma is not who is afraid of human rights, but rather who is afraid of local culture and the politics of vested interest in the implementation of our human rights obligations.